Good. Thank you. Thank you. So I'll carry on over here. High-level overview of legal investigation and strategy, knowing that part of the playbook is what are the playbooks that we have in order to be successful when we do have an incident, but more importantly, when we don't have an incident, because it's the practice that helps us be more resilient. So if you think about a slide like this is one of those slides that is truly a toolbox slide. If you take the picture of this slide, how do you use it? How do you create a map to understand what your objective is? What are your risks that you're trying to address? What is the strategy you need to employ? And what are the actions upon that strategy? You can really use this as a really good toolkit to inform your incident response plan, your risk register, and train your team on how to really address these objectives and risks. I mean, let's play one out. I don't know, reputational damage, Steve?
Sure.
Yeah.
By the way, it's kind of interesting, you know, the attorney is dressed like a CISO and the CISO is dressed like an attorney. It's just the way.
It's October, it's Halloween.
That's
you know?
right. So, yeah, I mean, if we take reputational damage and then trace that through, you know, obviously in the risk, from a risk standpoint, you're looking at press and social media, public statements, public-facing statements, and things like that. You know, what strategy then do you pair out to deal with that? And basically, it's you know, managing your public relations across jurisdictions and managing social media, having a coherent policy internally. From an actions standpoint, you know, it might involve hiring an external PR firm. Mm-hmm. Think about these things in advance. It's good to include lawyers. I mean, that's always the selling point, right? Include the lawyers. But it's actually good to include the lawyers because if you're going to be making public-facing statements about security or privacy or any of these things, you know, you can get yourself in trouble. So it's, you know, you can play a lot of defense even when you're trying to put the best foot forward for the company.
Thank you, Steve. And by the way, we didn't say this at the beginning, but we want to encourage questions. So please, as we go through, feel free to raise your hand or even at the end of a slide so that you don't forget your question at the end.
And, you know, Bernardo, too, while we're still on this one.
Yeah.
And I think that, you know, we all kind of have our specific role, whether it's CISO or lawyer or some other, you know, designee, and it's easy to, you know, to lose sight of the waterfront. So one of the things that we try to do with this slide, Bernardo and I, was put together kind of what it looks like. You know, what are all of our objectives? Yep. What's the waterfront in terms of risks? And then a laundry list of strategies and actions to deal with stuff. Not that it's exhaustive. There's more too, but
there's definitely more.
It's easy to lose sight of stuff.
Absolutely. Yeah. Threat modeling, how you put that into your incident response plan. You know, there's broader frameworks than this, but of course, this is a very good foundation. So what are questions that CISO should consider, right? So I use questions like this, and there's also a release by the National Association of Corporate Directors that was released, I think it was last year, that just asks very similar questions like this. What are the boards going to be asking if they're not asking? And if they're not asking this, what should we have the answers to so that they know that we're prepared? So for example, if you look at, are we prepared for a breach? Well, how complete is our incident response plan? How many tabletops have we performed? How many things did we do with different audiences? For example, did we do a tabletop with a technical audience versus a strategic and a more business-focused audience? These are how you can take one question and take specific strategies and actions to address that question. You know, we have others like, what kind of remediation should we execute on a certain incident? This is more tactical, right? And it's not something we would share with the board, but if they want to know how we would handle a certain scenario, we'd be more prepared to do that. The other key here is, how do we handle messaging? Messaging, we should be in sync with our legal and our HR and or communications team, and especially with legal, how do we engage external counsel, right? So this is really, for me at least, a very valuable tool that I know other larger bodies are starting to incorporate to make sure that you're prepared. Speaking of communication, let's talk a little bit about privilege.
Privilege on a Thursday at 5 p.m. God bless all of you. So attorney-client privilege. And so we've got kind of a framework here to think about attorney-client privilege and the attorney work product doctrine, which is another legal mechanism where certain types of things get protected from disclosure. But even before any of that, it's important to remember that privilege is, in the United States, a function of state law, right? So a statement that we make about what the law of privilege is in New York is maybe different than the law in Arizona. And so it's important to take a kind of a conservative and aggressive approach when trying to protect things with privilege. Attorney-client privilege covers communications between an attorney and a client. And if if you're going to involve a non-client in the communication, unless you've set up special mechanisms or documents, you're not going to have privilege. And in fact, the interesting thing about privilege is you can end up not only waiving privilege for a single document, but in certain jurisdictions, depending on the conduct undertaken, you can waive it for the whole series of communications. But attorney-client privilege is great. It pretty much holds up against any attack once you're able to assert it. Now, attorney work product is a slightly different animal. So if we don't have a communication between an attorney and a client, but we have an attorney or an attorney's agents doing work, doing analysis, preparing whatever, that will also be protected from disclosure as long as it's done in preparation or anticipation of litigation. So that's the work product doctrine. But between attorney-client privilege and the work product doctrine, it can cover a lot. Obviously very important in the context of breach, and we'll talk, or incident response and prep, and we'll talk more about that, because it turns out that there's a lot of moving parts and a lot of different parties, so it gets complicated.
Yes, sir. This is very important. I think especially in this day and age, when you look at, if you go back to what happened with Target, right, is what happens to a company and reputation and how you protect the wrong communication is just as important as how you protect the right communication. And then you fast forward to days like this week where I feel tired from just the alerts this week, but we also heard about Facebook. And gosh, as a CISO, I'm like, what do I have to go back to the office and worry about after just one day? But it helps that, yes, please.
So as a CISO, you obviously deal with a number of incidents, lots of security alerts, lots of potential incidents. Some of them are probably small and you can handle them internally. Some of them are maybe larger. You might need to get external help. At what point in time do you think about attorney-client privilege? At what point do you think about engaging external legal counsel to help protect the investigation and the communications related to the investigation? Because I would imagine some of the smaller incidents, maybe just handle it internally and you don't get legal counsel involved. So what's that threshold from your perspective?
Sure.
And Stephen, I'd love to hear from your perspective. What do you think is the right, or what's your perspective on it?
Right. So the earlier the better. Again,
Yes.
it sounds selfish, but no. One of the problems in a rapidly developing situation, whether it's incident response or other types of crises that happen to organizations, if an attorney is brought in midstream, you can have all sorts of ongoing lines of communication undertaken and that aren't going to be subject to privilege, and so you're trying to squeeze the toothpaste back in the tube, for privilege, and you really can't do that. We try and do it, right? You end up, re-engaging folks and doing all sorts of other weird contortions, but it's really an area where, and once counsel is involved, we'll take every action necessary to make sure stuff is privileged. But all the hard work is actually on the CISO and I know this is good foreshadowing, you've got your fingers squarely in the wound, but a lot of this is really on the CISO and the organization to put in place, kind of a formalized process that will trigger that. But I'll leave that to Bernardo to comment.
And thank you. And this comes back to playbooks, right? Every company has, the magic word for every company is what is the acceptable level of risk? And acceptable level of risk gets defined at such a macro level at the board level, but more importantly, it needs to be defined at an operational level so that the people on the ground, when they see that there's an asset that may have credit card data on it, that may have malware on it, that they know the right thing to do, which is don't shut the machine off, right? Things like that. But also, did we assess if there's critical information on there, or what we define to be critical, high value asset information on there? it's really that drives our response, right? Because immediately, based on the criticality of who got impacted, what's on that asset, and what that asset means to our business, I'm calling up legal. Legal in our company is very involved as far as the beginning of the process. And that's somewhat driven by me because I'm also a privacy professional, and I just feel married to legal in some respects. I just feel like we're partners in this risk game. So at least that's how we do it. And in my career, that's been very helpful, whether I've been a consultant or as a CISO in both either higher ed as well as corporate. It's been very, very helpful. Yeah. Any other questions that we can answer regarding that? Okay. Let's talk a little bit about nth party risk. Now, this is something that I'm starting to hear a lot more in the news, but I guess in our careers we've seen a lot of it, right? This is this third party risk concept and how legally we have protections in place with third parties. And in some cases, technically, we've done two types of assessment, and maybe three. The first is having the right to audit clause in your contracts with your vendors so that when you want to, and if you have the staff, or even if you think about today's super micro incident, if you're a company, you want to hire a third party and you want to investigate how their supply chain or how their technology is securing your product, great. So you do that legally. You then have a right to audit clause and you audit them. The second is how do you actually assess that risk? Do you use a third party to do that? Are they going to be qualified or not? And then thirdly, how do you understand the downstream risk? Do you know what vendors they're using to provide that service to you? And is that protected legally, and are you assessing that legally? So I have this thing where I like to talk a lot about CIAS. If you think about confidentiality, integrity, availability, but there's also safety. And people are like, why safety? Well, IoT now is one of those things. For example, if you are trying to understand if you're getting into an HVAC contract with your company, why would security be in the conversation? What we're trying to assess is, does that third party allow another third party to access their systems? And if so, then they have access to our environment remotely. That is a safety concern. And I need to understand who they're outsourcing their support to, because invariably they're going to have access to our environment when they try to troubleshoot our environment. And if the HVAC goes, so does the safety of our people. So all of a sudden, security is involved in assessing the safety risk from a technology perspective, but from an nth party vendor perspective. And we try to do that legally, we try to do that with assessments, and we try to do that through interviews. So that's how, I have these questions here that I think are really important to answer, right? How are we protecting ourselves legally? How are we performing assessments? And how are we doing shared assessment reviews? This is one last thing before I hand it over to Steve is, there's this concept of performing risk assessments ourselves, but there's also vendors that do shared risk assessments. And we can leverage the assessments from the industry partners and other companies that have assessed the risk of that vendor so that we don't have to depend on it ourselves. And I know there's some companies and products that are starting to put that out there in the marketplace so you can leverage that. So that's a very important tool to consider in the portfolio.
It's interesting too, that this issue comes up in terms of third-party risk. I mean, there's the the big vendors with the capital V, and then there's the all of the parties who are the sources of third-party code. Yeah. For the JavaScript third-party JavaScript that runs on your website, or the SDKs that are in your mobile apps and things like that. And what's a lot of times a very interesting question of what's the legal relationship. And a lot of times we take a little code from here, we take a little code from there, and it's devil take the hindmost. But depending on what's at stake and what data's at issue and whatnot, it's requires legal to be involved, certainly CISO to be involved, or have some type of process in place.
Absolutely.
It's something we see all the time, and of course it's you see it in the news media, and Target's a good example where, but it seems like it's always a third-party vendor or it's third-party code that you're relying on, and that's what gets, where the problem starts. But
yeah, and that also leads into more a deeper topic when we marry the prior topics together, right? The privilege and third party. So how do we handle that, Steve?
Yeah. So, and I like this slide. I didn't prepare it. My associate prepared it. God bless her. But so privilege and third parties. If a company retains an incident response vendor, or other parties to deal with a crisis or incident response, the communications and the document trail aren't going to be protected by privilege. It can be requested in litigation. It can be requested by a regulator, and it's out there. So to the greatest extent possible, whenever there's an incident, you want from the very inception of the relationship, you want the attorney to engage the party and make them an agent of the attorney. And the interesting thing too about one of the things that's listed here is the practical tips to safeguard privilege. Privilege is very much protecting privilege is very much about adhering to formalities. So it's important that every single email have the attorney-client privilege language on it, because believe it or not, if it comes up and you got to test the privilege, and and then the judge has an in-camera inspection, which only they see, and then you see everything is just plastered with attorney-client privilege, all of a sudden it's quacking like a duck. You've treated it as privileged, and the chances of it actually being maintained as privileged go up. If you get loosey-goosey with the formalities, and there's communications with the third parties that don't involve counsel, all of a sudden it raises the issue, well, maybe those aren't protected, right? So, you want to have legal counsel obviously involved for their input. That's critically important. But from a mechanism standpoint, to make sure that this is protected, if there's one thing that from me you walk out of here today, it's think about the formalities, right? You hear this thing, well, we're not going to elevate form over substance. Yes. For privilege, it's all about elevating form over substance, yes. Believe it or not. But it is. It's really, really important piece. So.
No, the other thing I want to ask is I want to address something called fatigue. When you're in the middle of an incident, fatigue starts to set in, and the key is if I could add to that is to have templates available to add footers to your signatures that have attorney-client privilege involved when you're involved in an incident. I know this stuff sounds like, oh, that's the extra stuff, but it matters because fatigue sets into the team. People get lazy. Not lazy, they're just tired, and we can't, we can't hurt them for that, but we want to make things as easy as possible. And this could be as easy as doing a session one day where you're doing a incident response session, and you're walking out of that with an actual action where everybody integrates these templates and these readiness components so that when there is an incident, attorney-client privilege is there and ready to use. Question? Oh.
Yeah, just curious from your perspective, to Bernardo's point, if you get tired and you forget to put attorney-client privilege on an email and you start to get a number of responses to it, and then maybe somebody realizes maybe 3 or 4 emails down the thread and they start to add it to it. I'm just curious, are those first 3 emails protected under attorney-client privilege or not?
So they were at one point. Whether or not they've maintained that privilege once you start to drop the designation would actually probably differ from state to state in terms of whether or not. Some states are very picky, about that. And if you, you hear the concept of waiver of privilege. And waivers actually, in a legal sense, has a very precise meaning. It means the intentional relinquishment of a known right. But waiver of privilege really isn't a waiver of privilege. And in a legal sense, it's really more estoppel. It's your conduct. And so if you, which means it rests on a much lighter trigger. So if you have emails where things have gotten fatigued or the lawyer isn't CC'd, for example, if the lawyer is CC'd but privilege isn't marked on it, you're probably still going to maintain privilege, external counsel, that is. But if people start communicating amongst themselves, the more it looks like it's outside of that stream, the greater the chance that privilege will be cratered. One point I wanted to make on the external piece, because in-house counsel can serve so many roles and wear very different hats, having in-house counsel attempt to perfect privilege is a very dodgy maneuver and sometimes unreliable, very unreliable in Europe, but also somewhat unreliable in the US. External counsel, on the other hand, pretty much again, you stick to the formalities and honor it, and you'll be able to maintain the privilege. But you're right, though. If things start to, if the heading starts to drop off, or you start dropping the attorney off the communication, the more that happens, the greater the risk that all of the whole chain could be waived, not just those communications. So yeah.
Mind me asking a second question, but is there any impact nowadays? There are a number of security leaders that report into CIOs, but it's starting to shift. So we see some security leaders reporting to general counsels or maybe COOs, CFOs, et cetera. But when they report into a general counsel and there's an incident, and ultimately the GC would have the accountability over the incident response, do you think there's an issue with leveraging the GC from a privilege perspective, or in that situation, would you strongly recommend that they engage outside legal counsel, given that the GC actually would own the security function and may not actually be able to assign privilege to the work?
Yeah, I think that's a great point, right? Like from a very salutary benefit of having the CISO under legal makes a lot of sense. But if you're actually tried to get privilege, then during an incident, there's the argument that, well, this isn't privileged at all because this is just part of the day-to-day way that the company operates and the way that it's set up. So, and again, it sounds awful because it always sounds like you're out there like, hire us. But whoever you hire, it's true that if you want the privilege, there's nothing like having external counsel to really stack the deck in your favor. God forbid it's challenged.
Please.
I know probably most of the people want to get off this subject, but does it matter by state about the attorney privilege or any of the privileges? And what if you get a plaintiff that wants to shop around from court to court to court, and then it's not satisfied with state and goes to federal court? Does that change any of this?
Yeah, so it does, and certainly plaintiffs do shop around for all sorts of things. Typically, plaintiffs shop based on applicable substantive law of the case. Can we get a longer statute of limitations? Can we actually procedural law? Can we make a claim that's available under one state law, not on another? Is common forum shopping. It could also be done on privilege. There's certainly differences in state law on privilege, and then in federal court. So federal court will apply the state law privilege for the jurisdiction in which it sits as a function of state law, typically. So again, it comes back to state law, all of which in terms of strategy means, as opposed to trying to operate to sort of the maximum breadth of what privilege might allow, you want to police it, have all the formalities, be very vigorous about that, because then you're going to protect that across jurisdictions. So I don't know if that's the answer is that, yeah, this stuff can vary from state to state, and it's kind of troubling, actually.
I also, another takeaway from this is you talk about PCI forensics investigators. For those that have to deal with PCI, this is yet another reason why it's important to engage, when you have an incident, to engage a forensics firm under legal counsel or external counsel, right? Because the way they engage them provides a lot more protections and advice that could potentially protect us more than if we just did it ourselves because we wanted to fast track through something. So there's this concept in PCI of I think it's a PFI, which is a payment forensics investigator, right? So how we play with those folks, we have to be very careful, and having to do that with an external counsel is the way to go. If you're ever in that situation or know someone that is, please. Would you apply the same approach if you have a company on retainer?
If we have an incident response company on retainer, right? And so, for example, for me, right, I work in the security organization, and our natural tendency would be, hey, we're going to go and engage company XYZ, right? They're going to, probably ask us for some logs, some information, and then they're going to, potentially make an assessment as to whether or not they need to send people. So, would you follow that path, or would you recommend that even in the case where I have a retainer, I should still go to outside counsel and then have them make that contact?
Can you take that, and then I want to add to it?
Yeah, I mean, typically, yeah. I mean, we recommend that that external counsel be featured in the incident response plan, either by designating someone specifically, or by a firm specifically, or by saying simply that it will be done. So yeah, I mean, it's typically the type of thing you'd want to do, especially because you don't necessarily know where things are going to end up. Something that starts as a minor incident, quote unquote, or investigation can sometimes balloon into, something more tectonic.
So to add to that, you will potentially, in some cases, get pushback from your business partners or even your legal department. We don't need to engage external counsel for every little thing, and that's fair. One of the ways to mitigate that is to have predefined scenarios in an incident response plan where legal is involved in the process. But then secondly, there's the concept that if you have a good relationship with an external counsel, you can call them up and say, hey, FYI, I'm investigating this thing. Because the key is to register a timeline of incident, when the incident starts. Register that timeline, even if it's just one email. And then they don't have to be, involved heavily, but at least the timeline has started such that if it is a serious incident, you can go back to that, right? And by the way, this assumes that you're going to get pushback from internally. Ideally, you don't get that pushback, and you can engage external counsel as much as necessary, depending on the appetite. Yeah, please.
Question just on the incident response plan.
Yes.
So while the CISO plays a big part in
Yes.
that plan, who owns that, and what are you seeing in a lot of firms these days? And is there a trend for it to be either owned by legal or by the risk team? What's your view on that?
So it could be, I'll give you a couple of examples, not to call anybody out, but there's the concept of the cybersecurity risk governance group owning it, such that the key members inside the group have their teams. So there's the crisis response team, there's the more security operations response team, and the report or the updates have to go to key members and key teams within the cybersecurity governance committee. That's one of the most ideal situations. The days, in my opinion, of where you have the chief risk officer or the chief legal officer owning it, I think are very high risk. Typically, leadership is about one person owning risk or one person owning something. But in terms of something like this that affects so many people in the company, where communications and HR and legal are involved, my opinion of all the models I've seen is to have the right teams within the cybersecurity governance committee own it. So there's a little bit of everybody in there.
So then in that cybersecurity governance team, who do they report into ultimately?
Ideally, a good structure would be that there's a chair or co-chair, and the CISO would be one of those.
Okay.
Yeah. Yeah. Any other questions? Yeah, governance is a key thing, and those are great questions, because I think what boards are looking for is to see how structured and how well are you folks playing well with each other, right, in the company, right? And governance is about tracking management and whether management is doing their job, and it's important to be in sync at the board and management level, in my opinion. I love this slide. So this is kind of, and we've seen this theme here, at least I've been here today, and I've seen a great theme that I like in the Mandiant slide, the FireEye slides, which are what do you do pre, during, and after incident. And here, if we look at this, designating counsel is very important, right? So for incident response, who do we go to when the crap hits the fan, for lack of a better term, right? That's what you really gotta have everybody on board on, because you don't want, when an incident happens, to say, who do we call? And more importantly, to have, we talked about external companies, having them on retainer. To have them on retainer already with external counsel paperwork is one of the best things to do. So just wanted to put out there. Having an incident response plan with input from counsel, external counsel, is also very important, because external counsel is seeing things that we just don't see, even if we have forensics firms that are partnering with us. External counsel are just seeing things, and they're seeing things happening in the courts that we just don't see. So I think that's really important also. Tabletop exercises. We know this in life, right? We are the habits that we keep, and the habits that we keep are the ones who take us through the battle, right? So if you look at most companies that fail, most teams that fail, it's because they haven't practiced it. practicing, whether it's on your one-on-ones, whether it's in your staff meetings, whether it's more sophisticated tabletops, I cannot say enough about this. Everybody should be in lockstep, and the more people you can bring into that table, the better. The discovery of the incident, right? So when you bring in external counsel immediately, that's what we recommend, right? I feel more protected, I feel better, but I also feel I'm in lockstep with my team internally when I do that. And I feel like I'm getting good advice that's current when I'm doing that. And then outside counsel directly engaging cybersecurity, forensic investigators. I read that bullet out specifically because that's what we talked about earlier. It is so important that you do this. I can't emphasize the importance of doing that. But then during an incident.
Yeah, so actually to pick up on a point that you made about the tabletop, well, first of all, I like the first two columns because it makes all this, the CISO do all the hard work. But in terms of actually training and undertaking exercises and tabletops, et cetera, fascinating, right? Because you did one for a very large company, and lo and behold, there's probably got 70 people involved, and there were 2 different incident response plans that showed up that were being, actualized during the course of the exercise. And from a lawyer's standpoint, this is horrific, right? Multiple incidents, but that would not have been surfaced but for the fact that they trained the incident response and actually did the exercise. And then, so then to skip ahead to the after, obviously that type of thing, wow, what a great pickup to then you go and clean that up. And these, by the way, the incident response plans, the competing incident response plans, were dramatically different. This is not like they were different versions of the same document. These are conceptually different. Yeah, and during, maintaining privilege for, in terms of outside counsel, once they're involved, it makes it easier for the organization because it should be, and it typically is, very much top of mind for the lawyer. So they're going to be aggressive about that. One of the things that's listed on this slide that's good too is it talks about controlling the extent of communication, right? So not only are we going to have it be protected by privilege, but we're going to have a control group where it's people that need to know and that are involved, and we're not going to circulate the communications outside of that. And again, it helps to buttress the argument, should privilege be tested subsequent to that, that this was in fact part of a, either an anticipation of litigation or for purposes of rendering legal advice, but that, to control that. So anyway, yeah.
Yeah, I mean, communication is really important, and we talked about having templates and attaching privilege and all of those components to communication. But then let's talk about how we communicate. So we talked about the prep, we've talked about the before, the during is the key, right? So now let's put it into practice. We then start putting emails about potentially sensitive stuff in clear text, and we start sending it out, non-encrypted emails. Or then we start sending Word documents that end up on everybody's laptop, right? So, what's going on with that, right? We've all done that at some point in our careers, and then we have board members that are potentially maybe the audit committee looking at this and then forwarding it to their Gmail account. Never heard of that, right? Let's not do any of that stuff, right? Let's stop that madness. First of all, Office 2016, we can password that, and we can get some protections out of that that are much better than before. We're talking about AES 256 encryption now. Not the best, right? But it's better than nothing. Just give a password, but when you give the password, to send it on text. And by the way, how are you communicating on text? Do you have some kind of secure texting going on? We should have that group text set up for the right people. Again, you can leverage your incident response plan to create the right teams and then go from there. Auditable repositories. Sometimes we like to use the cloud to communicate. And look, the cloud is only as secure as you make it. But the beauty about the cloud is that if you do it correctly, everything is auditable. And you can access it while you're in your cabin and you're critical to the incident response plan. So why not, right? But let's put the right procedures in place. And let's try not to send documents in email unless it is secure email, because version control is also a security mechanism. And when did we stop putting privilege, and then at what version did we start doing privilege again? Those kind of things are important, and version control is priceless. By the way, the cheapest version control is what I make my team do, and fortunately more people are doing it, which is international timestamp, file name _ international timestamp, right? And then maybe your initial. And maybe if you want to go crazy, you put it in military time and you put your, the time zone. But every single file save that happens within reason, every 30 minutes to an hour, has a time zone change or a file name change that reflects that in it. And that's a poor person's change repository system that adds to security. By the way, encrypted devices are important too. There's these concepts of these pin-controlled USBs. Those are much better than the ones that are encrypted and you plug in as software. Because when you plug them in, what if you bring your encrypted USB and it's actually, the document was downloaded on a Mac and then it's not compatible with a Word computer or Office computer, right? Or Microsoft computer. So you want to use one of those OS independent pin USBs. They're a little bit pricier, but they're worth it because you can then transport that stuff anywhere and you don't have to worry about as much about that getting compromised. Any questions about secure communications?
One of the things that
Yeah.
came up is that clients at times they choose to engage two different external IR teams.
Yes.
Have you guys faced any situations like that? What are some of the pros and cons of it, and how the legal complications with that? If one fails to include the privileged communication while the other does not, and they identify the same issue, or a breach that is, damaging to the client or whatnot. So if you could.
Yeah. So and we actually see that a fair amount, especially with larger incidents. There can be, in addition to sort of splitting up the burden of what's being tackled, there can also be good litigation reasons to do it in very specific cases. In specific cases where you'll want one of the parties to be able to have someone from that party testify, you will engage them under privilege, but then when the time comes and someone from there has to submit an expert report or submit some type of report that's not going to be privileged, you've dealt with them under a separate stream with separate considerations and being very careful about what is communicated and what is said, whereas you may have another vendor then that is absolutely going to be under the radar the whole time. And in fact, you can even have, again, if litigation is imminent, you'll have one vendor do advanced work and have the other one lag behind, actually, so that you're not putting in their hands anything that you don't already sort of smoked out. So there can be good reasons to do it. It does ratchet up the complexity, but it can be done, and it's done. But again, you want to guard against the screw-ups and the loosey-goosey stuff of communications.
Yeah, I think, Steve, that's also a risk-based approach based on the companies, because there's things that could go wrong. I used to be a student of trying to have multiple, but now I'm like, let's figure out what's the right one to have, and let's get more people be on the same page on it. Now, I did mention PFIs. It was payment, right? In that case, you don't have an option because the payment brand, if you have to comply with PCI and there's a security incident, the payment brands will give you the forensic investigator that they want to bring to the table. And in that case, not being a lawyer here, but I think you want to manage a risk and say, well, let me bring in my forensic investigator and make sure they're looking after our interests and maybe what we think is the major concern, right? With our external legal counsel, either case, you want external counsel to oversee both, right, Steve? I think you to oversee both vendors. You know. Yes.
The thing is, I've worked multiple PFIs.
Yes.
If you have a retainer, you will not be allowed by the payment card industries to have them do PFIs for you. You will have to find an independent forensic company to do the PFI. So the retainer, having a retainer with a forensic company invalidates them doing the investigation, because there is a clause which says you shouldn't have a prior relationship with the independent forensic investigator.
For the specific case of PCI. Yes.
Okay.
You-
So and that's from the SSC, from the council?
From the PCI Council.
Okay.
That's means there are
If you have it on
exceptions.
retainer, if you have them on retainer, correct?
Yep.
Right. Okay. Fair enough.
It's not retainer or for IR, but the clause is that any prior relationship with that company related to the systems involved in your breach, that excludes that company from doing any kind of independent PFI investigation.
Right. That's fair. Understood. Okay.
So
Okay.
it's kind of a sketchy. You can go and argue with the card brand, and sometimes they might.
And that's been my experience, right? So it's
Yeah.
like,
That's why you need external.
exactly. And I think it comes back to that, right? That's why I really welcome that, because your experience, especially when dealing with PCI, is valuable. And yet with PCI, I have found that the auditors and how you negotiate with the auditors, particularly with more experienced third-party advice,
I would just say
you know,
that
it really
doing a
matters. It plays a hand.
multi-million credit card thefts investigation, nobody should ever go through that because it's not fun.
Wow. So thank you for sharing that. Thank you. Any other questions? Okay, I want to carry on here. I think we have one more. Did you know? Did you know, Steve?
Did I know? So, you know, we've hit some of this, in-house versus external counsel, certainly. Updates to boards of directors. Again, you want to be careful how you capture and title certain communications, right? If you're doing an update to the board, you don't want it to be characterized as, you know, part of the business function. If it has to do with, if it's in anticipation of litigation, then you can mark it as such. And, you know, it's okay for it to have some long title that's meant to trigger privilege and to have the headings in the document that way. But again, downstream, courts will look at, well, what was the roles? What function was being executed here? Sharing privileged information waives the privilege, absolutely. And then, you know, great point on Europe here that, you know, a U.S. Attorney, a communication with a U.S. attorney is not going to necessarily support privilege in the EU. So if you are going to have communications there where you think privilege is going to be tested, get EU counsel involved. Plus, their law on privilege is different. It's not as expansive as ours. They still have it and similar concepts. And then it even differs between the UK, which has one type of legal system, versus the civil law countries. Again, they just have their own thing.
Steve, if I could also to add to that, privacy officers. I think in Europe, you need to have a data protection officer assigned in the company, if I'm not mistaken. But more importantly, you have to think about from a privacy perspective. Some companies don't have a privacy officer, and you want to be able to handle these type of situations in the right way, especially where you have time criticality as a component. For GDPR, you have 72 hours at the identification of a breach to notify, right, the data protection officer and then the data authorities.
Correct.
Yep. No, so that's really important.
And you know, to the extent you get roped into a designation of who's going to be a data protection officer, that's another thing where you want to rope in actually U.S. counsel and EU counsel. The DPOs have very specific duties that can conflict with duties to the organization. So you wouldn't want to have someone who's involved in audit, for example, be your DPO, because they have duties to data subjects. So their duties kind of run, you know, out toward, you know, not in a way that's necessarily going to protect the organization in the same way. So GDPR makes everything more complicated.
Oh, yes. These are the kind of things that are not necessarily sexy, but I'm telling you, they're more and more sexy, and I'll tell you why. Because when you're the person in the room that knows about these more complex risks to the company, all of a sudden you're more valuable to the client or to your company. And they're like, oh, well, you're not a lawyer, and how do you know this, right?
And data protection agreements, actually, under GDPR. So everyone is seeing these things shotgunning around. And we'll have, you know, so in addition to your security addendum, you're also going to have the security requirements in the addendum. But you're not required under GDPR to have an indemnity clause, but a lot of companies will work an indemnity clause into this. And then, you know, if you have counsel looking at it who maybe isn't familiar with it, well, gee, it must be required by Article 28, but it is not, right? And so then you end up walking into indemnity where you did not have to be didn't have to be subject to that obligation before. So, yeah, there's all kinds of stuff, chicanery going on with GDPR.
Any questions on this?
Might be out of time.
Okay, I think we have, I know we were running out of time here, but just want to leave this last slide up here. Avoid risk with third parties. Did we do this? Oh,
No,
we mentioned some of these.
We
though.
kind of
We
went over
mentioned
this stuff, so I think we're probably,
We talked about GDPR, and we're on time.
yeah, how about that?
Any questions? Yes.
Any advice for notification to regulators?
Well, first, let me, if I could take this first.
Yeah,
stab
go
at it.
ahead.
So,
Yeah.
first, obviously, you have to be on board. For me, I always think about governance committee. So I'm not taking action without at least members of the cybersecurity governance involved, and one of them is going to be legal. And where there is not complete assuredness, then I'm going to make sure that our external counsel is involved. And even in that case, where necessary, potentially the audit committee may need to know and may need to know under privilege. So that's a very important one. Yeah.
And different in the EU versus the US. And the decision doesn't necessarily have to be legal. A lot of times it's tactical based on where you think it's headed.
Any differences for Canada?
The PAVA, right? So
Yeah. I'm not, I didn't
yeah.
look at Canada
No.
recently, but we have other people for that, thank goodness.
specific-
Yeah,
Good
and
question. Yeah,
Specifically in the financial services industry?
Yeah.
It's a different regulator.
right.
Yeah, I haven't touched Canada yet, but now under my current role, I have Canada as a responsibility, and more I'm taking an interest in getting freshened up there again. But it's true, yeah.
So I think you had it on maybe first or second slide, so I sort of like pulled you back to that because we didn't really cover it. But I want to hear your thought process on complex investigations. How do you marriage the differences in the goals between the incident response team doing an investigation and external counsel being in there to protect, your legal risks, right? A classic example is you're into, week 2 of the investigation. The incident response team discovers there's 25 compromised servers. The attackers are in the environment. And then you have a critical decision, right? From a legal perspective, lawyers start thinking on due diligence. You've got the attacker alive, data may be leaving, whatever. But from an investigation perspective, it would be a mistake to remediate at that point because you haven't fully scoped the incident. You need to continue to investigate. Ideally, you need to leave the attackers still in the environment until you're ready to get them out. So how do you marriage that complex situation, right, between those two goals?
When you have an incident, in my experience, whether on the consulting or the full-time side, it's important to maintain a cadence of updates. That's managed by some either program manager or some manager that's making sure that on every call, every other call, external counsel is on that call. This would be a material event that requires an out-of-band call if you're not having daily calls, right? Because it's important that once you find a gold mine like that, that procedures are being adhered to per security incident response procedures, but that the right checkpoint is made with external counsel on the phone, if not in the room, to ensure that we're adhering to procedures and that we need to escalate as necessary. You want to add to that?
Yeah, and I think that a lot of times in practice, there turns out, at least in our experience, is that there tends to not be tension between the legal goals versus it really comes down to what ends up being, what has primacy for the organization, since ultimately there's a business purpose to this, whether it's managing risk, whether it's securing the environment or PR. And a lot of times what we try and do is provide tactical advice along these lines. So if you come across a situation where you want to leave the environment live, for example, there are times if you have the FBI involved, they'll want exactly that because they're right. But the thing is who have you involved? So as external counsel, you've got a decision to make about, okay, if we're going to be extending our legal risk by doing the right thing for the security investigation, maybe there's a way that we can get both birds with one stone. Maybe it means we need to bring in the regulator before we wanted to, right? So that we've got blessing or whatever, right? So, but anyway.
Yeah.
Typically everyone's rowing in the same direction. Otherwise, as the incident response counsel, you find yourself as being the former incident response counsel.
That's very true.
But yeah.
It's usually, in my experience, is the risk-based decision taken between the outside counsel and the committee, which is at that point running that incident, not the IR team, because usually it's above the IR team when you get all that in that situation.
Yeah, in my experience also, what we've done is also involve legal counsel in the review of our IRP to see that there were any points of conflict that they have from their robust experience, to see there could be a point of conflict here that we could resolve by just, changing the workflow or using this example. That's another way also.
So apologies if you covered this, but on the slide you had a recommendation that tabletop should be done under privilege, right? So can you explain, why tabletop should be done under privilege? And as a follow-up, my assumption is that you're really talking more about kind of enterprise level type of tabletop, not a more technical tabletop that, for example, a CSERT may do to run through like a DDoS playbook, for example.
Yeah, so, I would say, to rewind first, the reason that you want the privilege is if you're, typically you do this type of exercise, any exercise, and you're going to develop a document trail as a result, and there can be many things that aren't flattering. And so if you have the exercise and, here's the list of the 10 things that are god-awful, and now you've got a document. Now, 1 week later, before we've actually fixed anything or had a chance to really aggressively engage this stuff, you have a breach. And so now you have a non-privileged document that might relate directly to things where the company breached a duty of care or a legal duty. It's been reduced to a document. You've got an ongoing breach, and no matter what happens now, there's no way to put that under privilege when it's not. So that's the theory. That's the reasoning. And so if you think that you're going to be developing that type of document trail with an exercise, whether it's, they show up with 2 competing incident response plans, right? Like that's a bad thing. That would be a bad fact in litigation. And if the whole thing is privileged, it probably doesn't come out, or it doesn't come out like that. So I'd look to like what's the document stream going to be like that we're going to develop, or what are we going to find? And then based on that, you would try and wrap it under privilege if you could. Just a thought. I'm not sure I answered your question, so apologies if I didn't. But
at a lower level, a CSERT team, doing a tabletop of, a specific playbook that they have, right? That would be okay, not being done under privilege.
yeah, I mean, right. If you're not, and I haven't been involved in those specific things, so maybe that decision's made not to involve us with those. But yeah, I mean, you make your judgment based on the documents you're going to generate or the communications.
And from a risk-based approach at a more tactical level, the things that are going to surface from that are not going to be as critical as the CEO saying, oh, by the way, I forgot this $2 million blah, blah, blah that we need to do. That could be material. And in the very rare cases, what if you have a third party in the room doing a tabletop with you, and they're privileged, they have access to this information? You want to protect the output of that in an after-action report that's covered by privilege. I haven't been involved in one of those, but I know that there have been in my past clients that have done that.
Yeah.
Oh, yeah.
Can the client attorney privilege be invoked before engaging an external counsel?
Counsel? Yeah. So in the U.S., because the answer is maybe different in other jurisdictions, but if you've got steps that are being taken by the general counsel or other attorneys in the organization in anticipation, direct anticipation of litigation, then that may be privileged, may be more easily tested. But there are arguments that can be made that privilege gets generated earlier than that. It's just more difficult. Yeah, but it can happen.
Yeah, I'll let the expert answer that one.
All right.
Thank you. Thank you for your questions and your time.
Thanks. Thanks, everybody.